Hello, everyone. It's a pleasure to have you on board in another meeting here in the Arbitech column in the arbitration channel. If you don't follow the page, please put a like here and start following us. We've been doing that for 3 years, and a lot of amazing people have come here to discuss things about technology, regulation, and of course, dispute resolution. And this morning, this afternoon, depends on which time zone you are watching us. I have here Daniel, who is a very good friend of mine, who is a famous arbitrator and a lawyer here in Brazil. And we also have Lisa, which is a very well-reputed scholar in Russia, that they both will talk about a very interesting thing. We have regulatory sandbox here in Brazil. Of course, it's still developing. And we have a lot to bring from other jurisdictions in comparative law that we can learn, and we can foster the development of this technology that viabilized so many nice companies and corporations here in insurance, in financial. So I'm really excited with this talk, and I would like to hear a little bit about Daniel and Lisa. Of course, I know them, but I think it would be interesting for you to learn a little bit more about them. So Daniel, please, following the alphabetical order, if you can introduce yourself, and then Lisa.
Daniel, first of all, thanks for your kind invitation. You know, I'm a fan of your work, what you do in your law firm and in arbitration, in technology. So first of all, I would like to congratulate you for all the good work and all the events that you organize. And of course, I cannot forget about Lauro, Andrea, and everyone in the arbitration channel. They are fostering arbitration in Brazil and worldwide. And so I'm a really big, huge fan of what they are doing since 2020, 2019, since the channel was established. So thanks for this opportunity and for all the opportunities that you give the arbitration community in Brazil and the international community. So, I'm just, I'm an academic, an arbitrator, I'm a lawyer, and, I've been thriving and studying and dedicating myself to this topic for many years, and I've established the Revista Brasileira de Alternative Dispute Resolution, which is now one of the top journals in Brazil, and that's what we've been doing, and this topic here is very interesting because in Brazil we've had some regulatory sandbox with the central bank and in Rio the sandbox Rio, and so I think it's going to be a good discussion, and of course I'd like to thank Elizaveta Gromova. She's been my partner in academia, my researcher partner for years now, and she's a brilliant researcher in digital technologies in Russia and worldwide known. So thanks for being here. I know your time zone, you're 8 hours ahead, but thanks for being here too. So Daniel, thanks for this opportunity, and let's discuss it today.
Thank you, Daniel.
So, yes, I think it's my turn. So, boa tarde todos. That's all I can say in Portuguese. I tried my best. Sorry for my Russian accent. My name is Elizaveta Gromova. I am professor from National Research South Ural State University. It is somewhere in the middle of Russia. We have mountains, we have bears. Welcome, everyone. Maybe one day you would love to visit. And of course, I also want to say thanks to you, Daniel, and to all your teams. I really think the job you are doing is amazing because you give the opportunity to experts from across the globe to share the results of what they're doing, the results of the research, as we will do today. So thank you so much again. And yeah, we will talk today about sandboxes. It is the topic of my research. Once in 2018, I started. I fell in love. And this is still my current research interest. So myself and Daniel, we will do our best to make you fall in love with us. Thank you.
Thank you, Daniel. Thank you, Elisa. So, starting here our conversation that people are like looking forward to learn. I would like to start with a very basic question. So, what is a regulatory sandbox? What are the examples of regulatory sandbox that you have, like generally where it started and why it's important? I think that it's like the ABC of our talk, but I think it is important to level everyone on this subject.
Mimi, yeah, can I start? So I was maybe a bit childish right now, but it is actually connected, because what we think, the first thing about the term sandbox, it is something like some kids are playing in the sandbox and they building some towers and they ruining and they quarreling. So, well, actually, it is something like that, but more serious. Today, we are going to talk about regulatory sandboxes, and this is kind of control environment where we can firstly test the innovation, the technology, if it is good enough, if it is viable or not. And secondly, what is more important, we can test the regulation. The problem here, the biggest problem with innovations, with the digital technologies today, that they have this innovative nature. The innovative nature doesn't allow us to say, like, this is the best way to regulate. Sometimes we do not know how to regulate. And that is why, for example, now if you are talking about artificial intelligence, we still have this discussion. Should we grant artificial intelligence a personhood or not? So what does it mean for law? We do not know what to do. We do not know how to regulate. Of course, we can just, create some new regulation, which is kind of risky, because actually we are full of not very good laws. So this is not an option. Or we can do nothing, not to interfere, which is not good too. So maybe we should do an experiment, because in Russian we do not say regulatory sandbox, we say experimental legal regime. Yeah, it is. In Russia, we love all the, this complicated stuff. So it is experimental legal regime, because to make an experiment can be easier to find the truth, to find what regulation can be better. Let's experiment. Let's temporarily introduce some regulatory relaxations. And maybe we will understand that in this case, these innovations will be developed much better. For that, we need sandboxes, and this is what Sandbox is: a regulated and controlled environment where we can test innovation and try to find best approach for its regulation. And regulatory sandbox is very popular tool. It is widespread across the globe. Many countries have it. Daniel, you told us that in Brazil, you actually have, I checked today, I guess like 3 in fintech area, in energy sector, and one I found Rio, Sandbox Rio. So this and there are many sandboxes in Russia, in Italy, in United Arab Emirates, in China, in Great Britain. So I guess maybe it will be easier for now say which countries do not have it.
The first one was in UK, right? Was in 2014.
In 2014, United Kingdom was the first.
I think it was followed by Singapore, right? Singapore, they have like a very strong background on financial sandboxes. I'm not sure. I'm not expert here, but I've heard that also Singapore, they are really developing on sandboxes.
Yeah, so we have for now like pioneering countries which have really strong background. So first one was United Kingdom and Singapore, and also Australia. They are really progressive and their regulation is very balanced. I think we will talk about it later. So.
Okay. So bringing, thank you, Lisa. It was It was very good explanation, and bringing here for the dispute resolution side of things. When you have innovation, of course, you have conflict. And do you think that the lack, because generally there is not a dispute resolution provision or a dispute resolution system designed for sandboxes, we are like solving the problem with a regulatory sandbox. I mean, like the innovation problem, but we are not solving the conflict problem that may arise from this solution, this regulatory solution, this experimentative legislation regulation. So do you think it's a flaw? What do you think that is it the problem by not having a specific or a tailored designed dispute resolution system for sandboxes, Daniel, from your experience?
Well, I must say that any contract of adhesion, like the contracts that you sign on a take it or leave it basis, of course, this regulatory sandbox is in that basis, because when you are an applicant, when you join the regulatory sandboxes, you are adhering to the regulations there. So you don't negotiate the terms, the provisions. So you are just applying to make the product or to develop some technological product there. So I say that I always when you don't read a contract, please just read the dispute resolution clause. Look for the dispute resolution clause, because that actually reduce your risk perception in make that business, in signing that contract, because you know who to look for when you have a problem. That's the whole issue here. And myself and Elizaveta, we've been researching dispute resolution clauses for in lots of areas. For example, we have a paper on online sports betting, where we talk about dispute resolution clauses in their websites. We have a paper that we talk about ChatGPT in general and LLMs, and we also address the dispute resolution clause. A few people realize that, for example, ChatGPT changed their ADR provider from one to another, from New York to San Francisco, for example. So, because they don't read it. One of the biggest lies in the world is I read and I agree with the term. So this is one of the biggest lies that I've heard in mankind. So, and of course, we've just published a paper in the reputed journal named Conflict Resolution Quarterly. It's an American journal where we address this topic here of this webinar. And the paper, our research problem is this one that you just asked, Daniel. Is there a gap here? The regulatory sandbox are failing in not providing an ADR clause, a dispute resolution clause. And we researched all the sandbox that we could find. I never say all we research, because we always fail in finding some hidden thing or something like that. But most of the sandbox we researched in this paper, and we only found like 2 that provided a dispute resolution clause, but very weak one, like an ombudsman, which just receives a complaint in the Taiwanese the regulatory sandbox, and one in Australia, which had also a complaint mechanism. So it's not actually a dispute resolution robust clause. Go ahead,
Daniel. Can I ask you a question regarding this ombudsman? Is he appointed by the regulator or jointly appointed by the regulator and the company that's trying the sandbox? How is the...
No, it's already there. It's already there. It's an internal ombudsman, so it's not appointed by anyone. And that's where we found the flaw, because of course you can still solve your problems here, but you have to go to the state courts, So that's always a door inside the multi-door courthouse system, which is available there for the parties. But maybe it's not that efficient. I'm very sure it's not that efficient, because when you are in an experimental regime, you need a quick solution. And of course, if you use all the doors, probably negotiation, mediation, And arbitration or different types of arbitration, like fast track arbitration or something like that, maybe depending on the dispute. Because like Elizaveta said, and you said, many conflicts might arise. And when you see a contract or a regulatory sandbox, you have to analyze what potential conflicts might arise from that contract in order to tailor, to design your dispute resolution mechanism for that, specifically for that goal. So that's what we're talking about here in this research, and that's what we're reflecting, what we're thinking about.
Okay, thank you, Daniel. Just a short comic relief here. You said about you talk about the terms and conditions. I read research made with in Norway with Norwegian citizens, and they found that if a Norwegian citizen would stop and read all the terms and conditions and policies that he signed, he would take the same time as the time that you would take to read the Old Testament out loud. So I don't know anybody that
Cid Moreira.
Only Cid Moreira, exactly. Exactly.
Elizabeth, we have a guy that was a reporter, an anchorman in a huge journal, that he actually narrated the New Testament in CDs, and they used to. So that's our joke here. That's what we're saying.
Yeah, nowadays you could do with AI, but yeah, he actually did it. So imagine.
He did that back then when we had CDs, right? When we had CDs. That's it.
Yeah. No, that's just this not a joke, but this fun fact that I read about. So,
but then, Daniel, that's what I say. Read at least the dispute resolution clause in any contract you can. For example, games, online games. If you're playing StarCraft, if you're playing Pokemon Go in your cell phone, they all they all give you arbitration provisions in the US. And people have no idea if they have any problems in the game. They don't know where to go, what to search. And the same in sports betting. Of course, now that in Brazil that it's all regulated, so it's easier. But back then they used to bet and don't know that they would need to go to Cyprus in the judiciary, in the courts in Cyprus or whatever in England, and it's a Brazilian betting there. Sometimes they don't even speak English, they don't know where to go, what to do. So that's kind of risky, So I always say read at least the dispute resolution clause.
I think there are two points here that we should highlight. I think sometimes, especially when we are talking about bets here in Brazil, the strategy was exactly that to avoid consumers to file lawsuits. They had like the dispute resolution clause in Curacao and stuff like that. And regarding games, I work a lot with the industry, and what I found is that there's a lot that we can learn about, especially how they intermediate disputes between players. A lot to learn, especially by social media and e-commerce. They have like very, very, very avant-garde solutions, such as in League of Legends, World of Warcraft, and
NPC mediators.
Yeah. Exactly. Yeah, and there are problems all the time. So especially with not only with economic issues, but also with conflicts like hate speech in the platforms that are very common, and sometimes by minors. But this is another question. This is another issue.
There are some decisions, judicial decisions, jurisprudence here in Brazil that in the Rio, for example, that consider that your avatar adheres to your personality. So like canceling your avatar or something like that, if the provider does that, you are entitled to moral damage and stuff like that. So it's relevant. It's worth money, not to mention the virtual property that you take time to build and to gather or whatever. So it's a huge issue.
Yeah, of course, and that's one issue that takes us to the next question that I would like to hear you both on this. Because in the end, you talked about like very briefly, but I would like to take a deep look on it. Is that you have like a very difficult approach on innovative matters by the judiciary and sometimes by the arbitrators as well. So does this experimental framework and also a design tailored for it can help having like more specialized decisions and more accurate decisions on matters? Because we have to be realistic here. Okay, realpolitik. In the end, we can expect that a judge or even an arbitrator will be a specialist in a subject that was created. I mean, like in a technology that was created like last month. So, what do you think? Like sandboxes can help, and of course, the DSD for sandboxes can help solve this issue.
Elizaveta, you can talk about the problems that might arise in a
Well,
regulatory
what
framework.
what I firstly wanted to talk about sandboxes. Well, before, when I was answering on the first question, I said many good words, because we already said that we are fans, but we have a problems. Of course, we have a problems with the sandboxes, and the problems here is that the sandbox is an object of a criticism. Why? Because, as I told you, we are applying some regulatory relaxations here. And it influences a lot to a public trust. So at first, some countries like South Africa, they didn't want to implement sandbox mechanism. So they said, because they said like it is just a tool to bypass the law on consumers' protection. And this is really big problem because, we have some relaxations. We legally allow the relaxations. But in this case, how can we protect the consumers, for example? And the research gap we found in our paper, this lack of dispute resolution, this system. This is actually, the establishment of this dispute resolution system can influence both to, the sandbox reputation, and of course it will help, to resolve the conflicts, because we understand that all the conflicts arising from experimental regime must be solved very quickly, because our consumers, they are, somehow they are not protected. So we really need this dispute resolution system, which, as Daniel said, we do not all countries have.
So what Elizaveta is saying here, that we have like we identified that there might be more, okay, but we identified three major problems here, the three types of conflicts that might arise from a regulatory sandbox. First is the legal regime, like parties, applicants discussing the applicable regulation or stuffing, like, because we know that rules might always have ambiguity, might always have wrong interpretations or whatever, so they can be discussed. So is that going to be done in the judicial courts, in the state courts, or that's not the ideal thing? So the discussion about legal regimes is one big problem, like one conflict that might arise. The second one is the consumer rights, because as Elizaveta said, people build technology, new softwares or products or whatever, and they commercialize it, they test it in the market. So we're going to have real consumers, real life consumers here. So that's, the consumers are, I think, if you make a research in the judicial courts, the amount of lawsuits is bigger in the consumer rights, because of course in Brazil probably labor rights too, labor law too, but consumers, it must be the biggest amount in the judiciary. So we're going to have problems there with the consumers. And of course, the third problem that might arise is the IP, intellectual property. We might be inventing something which someone has already registered or invented or whatever. So that's the technological and IP problems. There might come some conflicts from there. And so we thought about designing a dispute resolution mechanism for each of these conflicts. For example, in legal regimes, you are discussing with the public entity. For example, the central bank here in Brazil, they had the sandboxes. You would discuss with them the problem. So we thought about a dispute board, which you establish a panel of 3 people at the beginning of the regulatory sandbox, and they would be there all the time to advise. It's a mixed a dispute board. We were applying here, looking at the ICC dispute board rules. So that's what we thought about. And then you can proceed if they don't solve the issue. And dispute boards, they have a huge, high success rate, 98% usually, that's what they say. But this 2% could go to binding arbitration afterwards, for example. And of course, there's no right answer here. We're just thinking about the doors that we have and how to combine them to bring an effective and a speedy way to solve a conflict. But that for sure would be easier to solve regulatory legal regimes problems, because the dispute board would just say, okay, you're right. Okay, the interpretation of this rule is this one. And of course, it's a 3-board panel. Specialists would come, like for you, for example, Daniel, you're a specialist in technology, and you would go there, be one of the members. And as we say in the paper, there's a problem here because one party would appoint one of the members, which would be, for example, the central bank, that, like we said, the public entity here responsible for the sandbox. And what about the other member, the member representing the institutions, the other parties that are applying, the applicants? So in the paper, we suggest that it could be like an association that represents the parties, and for that matter. So we give the UK example there, but those are issues that need to be that we need to think about. And so we respect equality here, and the due process and fairness and so on and so forth.
Yeah, and I wanted to say, we subdivide, as Daniel said, we subdivided possible disputes in 3 groups, and I wanted specifically to talk a bit more about poor consumers, because as Daniel said, we test innovations, we test the regulation in real life environment. If we don't have happy consumer, we will fail. Our experiment will fail. But here is great problem among most jurisdictions. Regretfully, consumers, despite their huge role in experimentation, they are mostly not protected. For example, in Russia, the legislation do not grant consumers with some compensations, extra compensations. I'm talking about extra because, of course, according to civil legislation, they are entitled to compensation, but it is a highly risk environment. So I guess in this case, consumers deserve more, but there is nothing. What is more? Do innovator has an insurance to pay for to consumers in case of some harm? No, it's up, according to Russian legislation, it is up to innovator to decide if they want or not. Of course, they do not want. They want, to consume some money. They want profit. So this is the biggest problem. So consumers are not protected. And while we understand this sandbox is a new tool for all countries. So because only Australia and some European countries, they have like some specific efficient protective measures. Like Australia has requires insurance and stuff like that. But it is just, like 2 or 3 countries among many countries. Well, in this case, while regulation is developing, let's at least offer to consumers some fast and efficient dispute resolution system. This is what I wanted to say.
No, thank you. No, yeah, it's very a lot of things to think about here. From what we are talking now, we should have this 360 view of the disputes that may arise from the sandbox. You may have, of course, and that's the vast bulk of disputes, this B2C disputes. You have B2B disputes in some cases. We have business to regulator disputes also, and business regulator to consumer disputes. And then you talk about dispute boards, and I think that's incredible. It could be an amazing idea for regulatory sandboxes. And summarizing like everything, I would like for you to address some things that I'm thinking here. First, when you're talking about sandboxes, experimentalism, legislation, we are talking about tests. If you're talking about tests, you are talking about data. And how can the collection of data be fostered by dispute resolution? And especially when you're talking about B2C, that you have like everywhere in the world, especially in Brazil, but everywhere in the world, a lot of disputes involving consumers, like in every B2C application. Does AI can help collect and bring intelligence to the regulator to decide whether he will keep this project or not? Yeah, I'll split my question in two, so you can deliver your answer on this, and then we move to another. Otherwise, it will be too much information. Please, I would like to hear you both.
Yeah, I heard two questions that I wanted to answer both immediately. First one, data. Yeah, the data is big problem according to in the sandbox. I want now to share you some Russian case. It is actually sandbox, data, and artificial intelligence. Yes, and looks like nothing works. So this is experiment regulatory sandbox, which is now in Moscow. And the idea was to test if artificial intelligence can be useful for healthcare system. We know we know the artificial intelligence has a great potential in healthcare too. And Russian developers, they developed what's so-called Botkin AI AI-based program that can detect cancer at early stages, which is of course very important. So we understand that artificial intelligence will be very useful. So that was the idea of Moscow government. Let's develop this technology for healthcare system. But we know that if we want the artificial intelligence works good, we need to upload a lot of data. The more, the better. But in this case, we are talking about medical patients' data, medical data according to Russian legislation and according to legislation of our countries, of course. It is the special category of data. They are under protection. They are protecting more than, just personal data. So what to do? We understand that we need data to train artificial intelligence to help in healthcare system. But on the other hand, it is a special category of the data. What to do? We cannot just use it. And government realized that, of course, maybe some patients will say, like, of course, please do whatever you want, maybe like 2 or 3. Then the rest will say, pay me money. And the rest will just, because they are, maybe do not like sharing, they will just say no. And in this case, they made a decision. Let's make this data anonymous. So yeah, let's anonymize all the data, which at first sight is a great decision. If it is anonymous, it is not personal. So let's go. It didn't work. Because they approve the decree or the decree on this experiment. They put provisions to the law on personal data protection, but what they didn't do, they didn't coordinate the procedure of anonymization. And after Moscow, the residents of Moscow realized that their personal data, which will be kind of anonymized, but while they didn't know how, because no one explained, and we didn't have technical standards or something like that, that somehow they will be anonymized or not. They said, no, we do not need this. And they said, you need to stop this experiment because it breaches our constitutional rights. So this is this is the problem with the data I wanted to share.
Yeah, that's a big problem, Daniel and Elizaveta, when we're talking about consumers here. And it's a huge topic in Brazil and worldwide. But AI would need data, but if you're talking about consumers, that's a huge problem. But if you're talking about the companies, that they could just waive, and the data could be gathered and worked in the AI. But of course, we know that there are only a few applicants in the regulatory sandbox, so which makes the job easier. But when we're talking about AI and ADR, for example, where AI to solve AI as a judge, the robot judge or something like that. I'm a supporter of, currently in the current state of technology, I'm a supporter of AI just as a necessary, like you're an arbitrator and you use AI for your research or something like that, with responsibility, of course, and not to solve the conflicts. But of course, it could be used to filter and to forward the conflict to the proper area within the regulatory sandbox, like text mining or something like that. But I don't know about you, Daniel. As a consumer, I hate talking to robots. They never forward me to the proper person that I want to talk about. And sometimes, they answer, did I solve your problem already? I said, no, come on, you did it. So it's, the robots, the chat, I'm talking about the chat robots, for example, they're not ideal. So if you're talking about ODR, that's another game, and you're just using technology to help, and for hearing, for systems in arbitration, in mediation. And I just read that, for example, in consumer disputes, we have in Brazil the consumidor.gov, consumer.gov, that could be used to mediate conflicts between regulatory sandboxes and public institutions and consumers. And I went to the EU, European Union online dispute resolution platform. They have one, but it's being discontinued now in July in 2025, because they realized that only 5% of the disputes were being forwarded to the, so it wasn't efficient in terms of cost. So they are discontinuing it into, which I think it's sad, because the citizens should use it better. And just an example, Daniel, I'm talking about judicial courts now. I'm living now in Brasilia, the capital of Brazil, and I just sued an air company here in Brasilia, not in Rio, where I was used to. And their justice here is fully digital. So, like, the conciliation hearing is digital, if you opt in, of course. In Rio, you have to go to the court, still have to go to the court just to hear, do you have an agreement? Do you have, like, any proposal here? No, we don't. So that you just go to the court for that. You waste like 3 or 4 hours sometimes waiting for a hearing or something like that. So that's not effective. So that's what we're talking about here. And, designing a dispute resolution mechanism here, especially for consumers, that could help a lot. And that would be, that will make the regulatory sandbox more safe. Let's put it, less, that consumers would like it, business would prefer it. And imagine being rely only in each business, each company dispute resolution way of doing it, or the judicial court. So that's not the best way to go here in the regulatory sandboxes.
And I also wanted to add a bit about ODR. Of course, ODR is very widespread and very helpful. But of course, when we are talking about designing dispute resolution system, we need to check the country legal system, legal culture, and legal tradition. Why I'm saying that? Because, for example, in Russia, we still do not have a platform for ADR. That was the idea, and our president even told that we need to do this, but still we do not have it. So for my country, maybe for now we're just not ready. So firstly, we need, to do the platform, and then to introduce this way of dispute resolution. And I also wanted to add about the artificial intelligence. Of course, artificial intelligence can help, and we know that China uses artificial intelligence for dispute resolution, uses a lot. Well, maybe in some unusual way for us, because we are, for example, here in Russia, we do not ready. And our judicial society, they said, no artificial intelligence as a judge. As assistant, okay, but not as judge. And we understand why, because technology can be biased. We expected technology to be neutral and impartial, and we do not have it because of, as I said, the biases. Well, what can we offer? As myself and Daniel, we have another paper. It is called Bossware technologies, the technologies that help to control the workers. And United States companies, they use artificial intelligence a lot to control workers. And artificial intelligence, according to all collected data, can even capable to make authorized, not just capable, but authorized to make a decision on some disciplinary penalties. And which is, of course, on the one hand, it is a big step in technological advancement in the use of artificial intelligence. On the other hand, it is very risky because technology can be biased. So this is what United States offer. Let's do some checkings. Let's do some audit before we will implement the technology. So this is, of course, what we could offer here. The same. Let's audit the technologies by several experts. If the technology will work, well, impartially, neutrally, in this case or not. So this can be also the answer to your question.
And Daniel, complementing what Elizaveta said, there's a key issue here. We have to look at the country in order to design a dispute resolution mechanism, because China, for example, when we talk about arbitrability, objective arbitrability, China doesn't allow arbitration with the public administration. In Brazil, we allowed that. It was allowed before by jurisprudence, for example, in mixed companies, but then in 2015, the law, the arbitration law was amended to allow it expressly, but China doesn't. So, and we're not talking about regulatory sandbox. Usually, it will involve a public entity there. So that's, they couldn't, for example, put the arbitration door for these types of conflicts with the public entity. It needed to go to the judicial courts, the judiciary. So that's one thing that we must bear in mind. We all must bear in mind.
No, thank you. One of the things that I'm thinking here regarding not only AI but very complex dispute resolution systems that could effectively address the complexity of regulatory sandboxes, such as a dispute board established from the beginning of the project, is the issue of costs. Because when you're talking about sandboxes, and generally you are dealing with companies that need to deploy its technology or its innovative application in a cost-effective manner. And I think that the paradox here, the dichotomy, is that AI could help both the regulator, of course, and the company with reducing costs. It won't be the perfect solution, especially in the state of the art of the technology. But in the opposite, in order to have like adequate awards and adequate solutions, you have to invest a lot of money in dispute resolution. So I think we are in this crossroads here, because AI could help, but could hinder effective solution. A dispute board, for instance, being the opposite extreme, could give the best solution for any issue that arises, but it will have a cost that you impact profoundly, very deeply in the deployment of the solution and the usage of the technology and the life cycle of the company. What do you think about that?
That's one solution that we have here in Brazil. I think it could be copied from us. That the sandbox, the public institution could, like we do in arbitration with public entities, they could just accredit ADR institution to work for them. So that's when there's a conflict, the private party would choose which institution would manage that conflict. So that's a good solution. So you only have the cost if the conflict arises specifically. Of course, dispute board, they could use an institution like that, but it has a cost, and that would be a discussion about since the beginning of the board would be established in the beginning of the regulatory sandbox, but it works really well. Only if I think it would be, that's a good reflection, a good that it would be ideal for very risky regulatory sandboxes, that the public entity would be sure that, okay, conflicts will arise here. Let's just be better with like a construction. The regular dispute boards, they are typical. We talk about that in the paper. Typical about construction disputes, because that conflicts will arise in a construction site. That's one of the truths about the world. You know it. So probably depends on the companies and the regulatory sandbox. We won't have that level of conflict, but it's design a dispute resolution mechanism. It's about brainstorming and trying to establish try to foresee the future there with what types of conflicts are going to arise. So there's not a correct one. It's not a one kind of answer here. We have many possibilities, and that's where's the beauty of dispute resolution.
Yeah, and I also, of course, what you said about cost efficient, this is, of course, very important for companies that are participants of the sandbox. But there is another issue that I also want to address. Well, maybe it shouldn't be too cost effective, too cost efficient. Why? Regulatory sandbox regime itself already, it is a set of relaxations. And for now, there are some scholars and politicians that say that regulatory sandbox actually actually is not a fair competition. So just imagine we have a company that applied to be within the experimentation. So it was granted with some relaxations. For example, to test driverless taxi in Russia, we allow 14 relaxations. I no fingers enough. 14 relaxations, which is actually not, on the view of the innovators that are not in the sandbox, is not very much fair. So that is why there is a threat to fair competition here. And so maybe, of course, we try our best to propose the most efficient dispute resolution system here. But what we need to do, to implement it properly into national legal system. Otherwise, we will face again with the lack of public trust. And I strongly believe that any legal tool will only work if it is balanced, if it ensures the balance of society, state, and business. This is what I want you to think about too.
Yeah, and bringing Another issue here is that I totally agree with you, Lisa, but in the other hand, the risk of bringing too many costs and too many hardships to the regulatory sandbox process is in opposite of bringing innovation. Is bringing much higher market concentration. And this whole idea in Brazil, we had like this legal framework for startups. Me and Daniel, we had like a project that didn't leave the paper. It was the idea to create like fast track proceedings for startups when going through an arbitration proceeding, using the article that the law created to define what is a startup. So the idea was like only, and for instance, we could have like sandbox proposals, which only startups could participate. In order, otherwise you have like the big tech, only big techs participating in fostering market concentration. That in the end of the day, we wouldn't want it. So I think that's the problem here that we face. Yeah, that's no solution. The nice thing that here we could find like there are many ideas that we need to solve, like many ideas for papers.
Yeah.
And I think that one of these ideas are how a perfect or like the quasi perfect dispute resolution system could be developed for sandboxes that could bring the best of AI and like the ODR technologies, and also the lessons learned by arbitral tribunals and also dispute boards, and create like the most effective solution. Of course, thinking about each jurisdiction, because we have like this anthropological side of everything that needs to be observed when you are developing a dispute resolution system. And also regarding this effectiveness and the lift of some regulations in order for the sandbox to participate. And I think that one thing that advocates for not allowing poor companies to participate is that you have a very serious liability regime. Because, for instance, if you're talking about autonomous driving, you're talking about liability. And I use it to joke that if we had like autonomous driving vehicles here in Brazil, you wouldn't have to lift like 1, 2, 5, 10, or 14 articles of our traffic code. You'd have like to substitute it by the Summa Theologica from Tomás de Aquino. Because in the end, it's about much more about ethical issues than how to guide the autonomous driver. In the end, it's like much more simple. The difficulty here is because you have a law and you have like to tear apart the law, because it's a new law that would need to be created. And in each technology, you have this challenge. So yeah, I think in the end, it's more questions than answers, and I think that's the beauty of the things when you talk about innovation and sandboxes. I don't know what you think.
Yeah, you brought a good analogy here, Daniel, because you talk about Summa Theologica from Thomas de Aquino, and it's an unfinished book, because he written 3 parts and he died before finishing the 4th part. So that's what's innovation is about. We're always evolving, and like Elizaveta said, regulatory sandboxes is an evolving tool, an evolving regulatory framework, and that's what we're trying to bring here, and to think about mechanisms that could help to solve issues, but it needs to make the regulatory sandboxes viable, not establishing costs that would make it unbearable, let's say it. So that's why this brainstorming here has limitations, because it's impossible to analyze every jurisdiction and its limitations, its arbitrability. If it's UNCITRAL based, then that would make us like Habermas, like the universal regulatory sandbox model, which is absolutely impossible to establish. Like the human rights, there's always discussion about human rights and its universal, if it's universal or not, if we should respect particularities of each country. So we're talking about the same. At the end of the day, it's the same discussion here.
Exactly. We are coming unfortunately, we are coming to an end of our talk. We could spend like hours and hours here because I love this subject and I love hearing you both. But here I make like a public invitation for you to come back here, and we have many things to discuss, and what you've been studying and writing about researching. It totally fits on what we discuss here in the Arbitech column in the arbitration channel. So I'd love to have you here again many times. And to end our conversation here, I'd like to hear like your final notes on your talk, and then we can end the discussion.
Russia first, please.
Well, yeah, I would really stay with both of you and discussed it a lot more. And now in my head, there are some interesting ideas on further papers. I'm a nerd. I'm so sorry. I'm so sorry for this. But generally, as a researcher, a fan of regulatory sandboxes, what I can see here, this is a really unorthodox tool. It can bring so many benefits, but of course it needs proper regulation, because sometimes legislators, they do not pay too much attention. And that is why we have national models of potentially good sandboxes, but somehow it doesn't work. So we need the help of scholars, of the research community. For that, I love digital law area. We all can contribute. So we need, to unite, to contribute for better development of the legislation of regulatory sandboxes. And of course, we should do our best to make dispute resolution system more efficient. So that is what was the idea, and this is what was the effort of myself and Daniel. And Daniel, thank you so much for this opportunity for us to share. We love sharing our research. It is like, it's like a kids. So thank you so much for this opportunity. And of course, we are always ready to meet you here and to discuss, because you are a great person to whom we can discuss our ideas. Thank you so much for this too. So I hope we will see each other soon many times.
Thank you. And before Daniel, you speak, I would like to say something. Добрый вечер.
Вау! Замечательно, хорошо. Perfeito.
You should visit Russia, Daniel. It's amazing. I had the opportunity to go last year. It's an amazing country.
Yeah, I've never been to, but yeah, it's definitely on my bucket list. Yeah, and it's a huge country that not only one visit. I bet that you plan to go back. There are so many nice places to see, and yeah, definitely.
Sometimes people do not want to come back to their countries after visiting Russia.
I would say the same about Brazil. So we are waiting for you here, Lisa.
Oh, thank you so much. Спасибо.
They have 11 time zones, Daniel. 11 different time zones in Russia.
Crazy.
So
crazy.
It's huge.
And I get worried when I go to Rondônia because I'm 1 hour. We have 2 time zones here in Brazil, Lisa, just for you.
I think we have 3 because of Fernando de Noronha, something like that.
Yeah,
I think so.
Just 2.
Yeah, you're correct.
We have like 10. Welcome to Russia.
You have 11. I studied it. You have 11. 11, I think so. But just Daniel, you're amazing, great moderator, and a very good specialist in technology and data protection, and and so on and so forth. So thanks for inviting us here. Elizaveta, you've been my researcher partner for years now. We have many papers, and it's always a pleasure to be here with you and to learn with you at the end of the day, because I'm always learning about this topic, that sandbox that you've been researching for many years. So Daniel, we'll be in other events, webinars together. We already invited you for one. It's going to happen real soon. And we're always here to go on board with you and whenever you invite us. Thanks a lot for the opportunity.
No, I thank you, and keep writing, because I love the papers that you write. So keep writing. I'll be reading, like I'm reading every one of them. So yeah, that's it. So guys that you are watching us, you can follow Lisa and Daniel on LinkedIn. And if you have any questions or you want to follow up with any issues that we discussed here, they are very accessible. So just message them, and they will help you out. So, and thank you, everyone. Thank you, Lisa. Thank you, Daniel.
Thank you.
See you. Bye-bye.
Das Vidania.
До свидания.